Tip number 6, request a statement of decision. And if you're still unhappy with the statement of decision, object to the statement of decision. Now, Jeff, this is probably a subject worthy of its own episode because there are a lot of angles to explore here. But probably the biggest takeaway is don't be tricked into thinking that a tentative decision is the same thing as a statement of decision. You ever had that ambiguity come up, Jeff?
I have an appeal right now. It's a family law appeal where not only were the parties tricked into that, but the judge was tricked into that, meaning the judge thought his tentative decision was sufficient. He was asked by the losing party to issue a statement of decision. He said, I don't need to do it. Here's my tentative. We're having a chat about that in the Court of Appeal right now.
Oh, yeah. I was at a panel once, and I remember a judge talking about one of her colleagues had a habit of issuing tentative decisions, but doing it in writing in a document titled Statement of Decision, with the intention being that if the judge called it a statement of decision, maybe the parties would be tricked into thinking it was what it says it is, a statement of decision, rather than a tentative, and they would not issue the formal request for a statement of decision and go through the objection process and thereby waive their right to a statement of decision. And why is a statement of decision important is because if you correctly request a statement of decision and object to any deficiencies or omissions in the statement of decision, then you get to defeat the doctrine of implied findings. And that is a very powerful doctrine for any respondent on appeal because you can point to the trial judge's decision and say, look, if there are any findings that were missing, then the Court of Appeal has to infer that they were there anyway. They were just that they were implied by the trial court. And as long as they're supported by substantial evidence, which almost everything always is, then you have to affirm the judgment. So it's very important, if you want any hope of reversal, to request a statement of decision so that the trial court's judgment is limited to the four corners of whatever is in that statement of decision.
Right. And here's an interesting take on this issue. Suppose you have either a bifurcated trial or a family law case with issues where there's reserved jurisdiction, and the trial judge announces his ruling on some of the issues and says, but you know what, on the balance of these issues, we'll rule on that later. Does that announcing of that decision on some but not all of the issues to be resolved, does that trigger the timeline or deadline to request a statement of decision?
Yeah, I had not seen that come up, Jeff. My hunch would have been to go ahead and just assume that that's a statement, a tentative, and go ahead and treat that as starting the 10-day deadline to request a formal statement of decision.
Well, let me give you two answers. One, no trial lawyer ever lost an appeal from requesting a statement of decision too often or too many times.
Right.
But the actual rule is that the time to request a statement of decision only begins to run once all issues are announced and ruled on. So if there's some sort of statement that there's issues to be reserved in the future, you don't need to request a statement of decision. That case is Wallace v. PHL Associates Inc. from 2013. We'll put that in the show notes.
Okay, that's good to know. Okay, so let's just deem that the tentative is to be continued.
Yeah, and I guess I'm not sure, we might have glossed over this, that if you want to request a statement of decision, if the trial is less than 8 hours, you got to do it before you submit on the evidence. And if it's more than 8 hours, then you got to request it within 10 days of the tentative.
Correct.
Yeah. And let me offer my favorite Orange County Superior Court story on this subject. I had a case that I thought went really poorly for me. It was a bench decision. We were the defendant. I thought it went really badly. And as we walked out as a one-day trial, I said, "Oh, Your Honor, we're going to request a statement of decision." And the judge said, "Mr. Lewis," this is a judge no longer on the bench, "Mr. Lewis, you're a fool." He said that in front of my client. It had led to a very awkward discussion in the hallway with my client about why I did that. We won, but I always think about that when I'm standing up and requesting a statement of decision. Am I making the right move? That judge's voice has left an imprint on my brain.
Well, and if you're the losing party, if you're the aggrieved party, I'd say always make a request for statement of decision. If you're the prevailing party, then quite possibly you do not want to request a statement of decision. Can you think of cases where you would want to request it, even if you're the if the prevailing party?
No, but the question is, how do you know? I mean, I left that trial that day thinking I had lost.
That's right.
And it was only when I received the tentative later on that I realized I'd won.
Yeah, was that a trial under a day long?
Yes, it was a short cause, very short 1-day trial.
Yeah, so you don't know. I guess if by the judge calling you a fool, was he trying to hint that you should withdraw your request?
I think so. I think he was saying, "You've won, Mr. Lewis. You're making more work for yourself." But I guess I'm bad at reading tea leaves.
Yeah. Well, on the flip side of that, I had a trial once under a day long. It was a petition for writ of mandamus. The hearing was, an hour and a half long. So it was under a day. If any party wanted to request a statement of decision, they had to do it before they submitted. The judge, who's now no longer on the bench, went to each side of the table and said, "Do you submit?" "Yes, Your Honor." "Do you submit?" "Yes, Your Honor." "Okay, both sides have submitted and no one asked for a statement of decision, so I don't have to give one." And then proceeded to grant our petition for writ of mandamus.
Wow.
Boy, were we happy that that the other side did not request a statement of decision, but neither side had any information.
Interesting.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.